I'll turn it over to you.
Yes, great. Thanks, David. So I did go ahead and just start the recording. We do record these meetings for the purposes of helping us to distill the notes afterwards. We also share the recordings on our website following the meeting in case anyone's interested in reviewing. In terms of just some other operating procedures, just recapping that if you do have any technical difficulties joining the meeting, you are welcome to dial in over the phone using the information provided in the calendar invitation. It's also available on our meeting schedule webpage. You can also reach out to me if the technical issues persist and you need some help troubleshooting. I can do my best to be of service there. We do ask that participants mute their lines, of course, when they're not speaking. This helps us cut down on background noise. If there does end up being some background noise somewhere, we may mute your line for you, but you are welcome to unmute yourself to speak. We do ask that folks use the raise the hand function that looks like the little hand up at the bottom of your screen. This just helps us manage the flow of the conversation a bit better. And I do see that there are a couple of folks joining us over the phone. So if you would like to speak up and you're on the phone, please just announce yourself when you would like to speak so that we know who you are. And we will do our best to also kind of pause intermittently to ask folks for comment, whether on the phone or otherwise. So with that out of the way, David, if you have any general opening remarks, I would hand it back to you before we move forward with the discussion. And you are muted.
Still, I feel like a newbie when it comes to using all this technology around communicating in a virtual sense. I'm always forgetting the mute button. So we have a few sections to cover today, but we are making good progress through this first round. In fact, in the next two sections, the last two sections that we'll have for today, not the first one, given the time permits, there aren't a lot of changes that were proposed. It doesn't mean we can't make changes. It doesn't mean in the next round there won't be more changes, but getting this first round of reviews, which is going from section 01 through section 12 of the regs, has been really important for us to try to get through. But please note that this is a first pass and that there'll be other opportunities, several actually, for changes to be made. So as we're talking today, if we don't get to an area that you think is important, just note that there'll be opportunities to come back to it. And at the same time, we're a long way from having these ready to be released for informal public comment. It's a process, and thanks to you all and the great intellectual thought process that you've put into this, we've made a good bit of headway on trying to advance these regulations. So to that end, we appreciate it. So Alana, without further ado.
All right, thanks, David. So just a quick recap of the progress we made during the last meeting. We got through a good amount of review of changes to sections 6, 7, and 8. So those were changes regarding auditing requirements, remedial actions to be taken by an HIE, and then the notice of breach and non-HIPAA violation. So Kelly, if you'll go ahead and bring up the regulations document, we will be picking it up today. And if you could blow that up, zoom in a little bit for us, that would be great. We will be picking it up in section 8. So that is the notice of breach and non-HIPAA violation. There are just a few edits remaining in that section. So picking it up in 08D6. And just a quick overview of what you're looking at here. So the track changes that appear in green on your screen are the edits proposed by Post and Shell. So those are the proposed changes that we're reviewing. To the right, you'll see comment boxes that say MHCC with a little red M. Those are comments and feedback that we've received from the policy board along the way. So that may be during these policy board meetings or in writing. And as we go along, Kelly will be entering additional edits and comments based on the conversation that we have. So that'll be the process moving forward. So if we pick it up with 08D6, again, this is referring to written notice to a healthcare consumer in the event that a breach or non-HIPAA violation has occurred, and what the notification to the consumer will include. So the first two edits that you see on your screen include a participating organization and an HIE as entities that may take remedial actions and may be the appropriate point of contact. So I will pause there to see if anyone has any thoughts regarding those edits. Okay, hearing none, then moving down to F. The addition in F.
I'm sorry, this is Walter. I was trying to get out of mute, but can I ask a quick question on that one?
Yes, of course.
So by adding participating organization, I think what this is in effect doing is adding a requirement for the participating organization to report and to, for example, provide contact information and these other elements. Is that correct?
So the addition of the participating organization in C is just to include that written notification about the breach or non-HIPAA violation, include information about or contact information specifically for the participating organization. So before it was just required that the written notification include contact information for the HIE.
Yes.
If the consumer wanted to get more information. This is including a requirement to include contact information for the participating organization as well.
I understand. Thank you.
Sure. Okay. Then the addition in F is to include information within that same notification about any steps an HIE will take to provide credit monitoring or protection. Yes, Pamela.
I was just going to say that, I mean, I think most of the times you have these breaches, it doesn't include information that would actually create a risk of identity theft. I mean, it's there's no social security numbers. It's unlikely to be financial. I wonder if we want to qualify this to say, I mean, to the extent reasonable or to the extent appropriate given the information breached, or, something, because I feel like this sort of sets up an expectation that the HIE would provide these kinds of services. And in some circumstances, there may not be any services that sort of fit the situation.
Okay. So we probably have to think about that for a moment, but Adrian, did you want to say anything specifically to what Pamela's talking about? Or
yeah, I was just going to ask if this is setting up an intention that the HIE would be expected to offer these services. So I didn't necessarily read it that way, that maybe it was, if you are going to offer this, you need to include it in the notice. But if you read it that way, I'm not sure why we need to include it in the regulations. So to Pamela's point, I'm not, it might be concerning if you're setting up an expectation that the HIE, every time there is some type of breach, would need to offer credit monitoring or credit protection. Because to her point, a lot of times, especially for the non-HIPAA breaches, because this is for both, it might be, I don't want to call any type of breach minor, but it might be something that wouldn't necessarily have a risk for credit or financial issues.
So
and that was my point, is that it says information about what measures the HIE intends to provide to the healthcare consumer. There's sort of an expectation that they're going to provide some measure, that there is a measure they're going to offer. And I guess my point is there may not be a measure in certain circumstances.
But Pamela, just help me understand, and Adrian, because it says the written notification shall include, but couldn't the written notification say that, that the HIE may or may not provide any of the, any sort of services, but that would be in that notification. And the reg is just saying you have to make it clear in that notice that you may or may not do something, but you can't ignore it. You have to say, maybe some HIEs might say if we determine it affects more than X number of individuals or something like that, as opposed to anything else.
So I wonder if we can just literally add something like, if any. So it's information about what measures the HIE intends to provide to the healthcare consumer, if any, so there's just Yes,
makes sense.
something to sort of say there may not be any.
Okay. Anyone? So Adrian, does that seem to address your point?
Yep, I agree totally.
And I hear a
Yeah,
hand.
can I just ask a question here too? This Rob Horst with Audacious for some of the experts on the phone, maybe like Pam. I like as an HIE, and if there is a breach, like isn't it the covered entity's responsibility to actually notify the consumer and not the HIE? Like, I mean, the HIE obviously has responsibility there, but typically they're a business associate to the covered entities themselves. So like, is this setting up the HIEs to perform an act which they're not really set up to perform? I mean, does that make sense? Pamela, I don't know if you have perspective
Your
on that.
point well taken, and I'm trying to get my head back into it because it's been a while, but you're right. And I just, one of the things I can't tell if it's in here and I don't have it up separately is whether this is all delegatable in the participating organization, the participating agreement, because I think that's how it typically goes, which is this is an obligation in the event there is a breach through an HIE. I don't have any problem with, as long as there's language that makes it clear that this can be delegated to the participating organization.
So in this section, just keep in mind, everyone, this section is 08, which is notice of a breach and a non-HIPAA violation. So the HIEs are responsible for doing for both in this regulation, because going back 10 plus years, it was the feeling of the stakeholders that these regulations are sort of like HIPAA plus one. And so the idea is that even though a covered entity may be responsible to do something, it didn't let the HIEs off the hook, if you will, as a business associate. It was we expect more from these HIEs, and since there's a non-HIPAA violation component built in, but and that would not affect the covered entity.
I think the only thing I would want to make sure is that we're not duplicating the notice. I mean, I don't think a consumer should get two notices on the same incident. And I think that would be the only concern I would have, as I don't disagree with you, David, but if it is a HIPAA breach and that's been passed on to the participating organization to report, we wouldn't want the consumer to think there's been two separate incidents or be notified twice on the same issue.
So let's add that as a comment, because maybe we can figure out how to work that in. So that's a good point. You're saying we don't want multiple notices to the same organization. And I think to Rob's point, because the bar is higher on HIEs in Maryland than what HIPAA would impose. So that's part of the reason why we have this whole section about non-HIPAA covered violations.
So David, I see a few folks with their hands raised. Kim Camerata.
Yeah, just getting back to the language in F, if you're pulling out the specific examples such as credit monitoring or credit protection, you need some descriptor, and I would suggest information about what remedial measures the HIE intends to provide to the healthcare consumer, if any, if that's what you guys want to add, but you need a descriptor.
Yep, that's a good point.
Thank you. Clay, I think you were next.
Hi, I had a question about determining who would be the covered entity. If you've got a patient's records that have been coming from a number of entities, different providers, maybe from a payer, how do you attribute in a breach of an HIE who the covered entity is that's accountable?
So so Clay, good afternoon. Thanks for joining us. What specifically are you referring to? Is it G1? Is it 5B? Take us to the citation. So let's work from that.
Well, it was really the discussion that we were having a minute ago. And I agree, we don't want consumers getting multiple notifications, but it was a discussion about the covered entity would be providing for a HIPAA breach. But the question I have is, you're likely to have data flowing through the HIE, or depending on the model of the HIE, potentially stored in the HIE, that is attributable and to a number of different covered entities. So I'm not sure how you go back to a particular one to say it's your responsibility to do the notification.
I see what you're saying. So it kind of builds on the conversation about not having multiple notices going out, when in fact it could be because it's data from lots of different sources, it's not attributed to any one covered entity. But there's elements in the regulation that allows the HIEs to do investigations to determine if it's the HIE's responsibility or if it's the covered entity's and I say responsibility, meaning that the breach is attributed to them. Because it always follows an investigation. It isn't that boom, it happened. The HIEs have to essentially say, yeah, it does track back to us, as opposed to, oh no, we just happen to be in the chain. This is really caused by, healthcare provider A and B.
I hear you, David, but I still think that there is a likelihood that a threat actor will be in an HIE for a period of time. And therefore, any transactions that flowed during that period of time will probably be suspect. And any given individual may be attributable to multiple participating organizations. So I understand the notion of the covered entity and don't disagree with that. I'm just trying to also make sure that we recognize that that may be a difficult thing to figure out who to attribute that responsibility in the event of a breach.
Yeah, no, fair enough, and that's an important point. I think it's good to call that out, and I think every situation will be different.
Dr. Suarez, you have your hand raised?
Yes, I was trying to go back to understand this concept of the non-HIPAA breach or violation. And I mean, as I see it at the top and in other places in this, we refer as breach or non-HIPAA violation. And so if we're talking about a breach that is not a HIPAA breach, that's one thing. But in here, it gives the impression that in all these statements where it says, the written notice shall include a description of the breach or non-HIPAA violation, it seems to me that it might be more clear to say a description of the non-HIPAA breach or violation. Because we're talking at the beginning of this whole section where it says, 0.8 notice of breach or non-HIPAA violation. We say numbers or letter C, where a breach or violation is not a breach under HIPAA. So across the board, we're talking about non-HIPAA breaches and non-HIPAA violation. Is that correct?
No, if I understand your question right now, because 08 is notice of a breach and a non-HIPAA violation. And then so we have to go back to the definitions to look at what constitutes a non-HIPAA violation or a breach.
Well, is a breach a non-HIPAA breach?
So now, again, I'd like to claim I have 55 pages memorized.
Well, no, if you go to page 39 at the top, where it says 08, notice of breach and non-HIPAA violation, and you go to C, it says there where a breach or violation is not a breach under HIPAA. So it means that the breach was not a breach under HIPAA. It was a breach under other. So it's a non-HIPAA breach. If I'm following the logic in C, which is the one that is structuring the entire rest of the section. In B, we're saying if any breach or violation is considered a breach under HIPAA, meaning is a HIPAA breach, then we follow HIPAA. But if the breach or violation is not a breach under HIPAA, so it's a non-HIPAA breach, then we follow all these elements. And my sense is that will help clarify a lot of these questions that I had anyway, and somewhat of a confusion about what is what, you know.
Yeah, so I mean, I think you're not raising a question so much as you're just making a point that under the additions of B, the changes to B and then C spell out when is a HIPAA, when do we follow the requirements of HIPAA, and when do we follow the notice of a non-HIPAA violation?
I'm actually making a very direct recommendation that we move the term non-HIPAA to put it before breach. So 08 will be notice of non-HIPAA breach or violation. And then
Okay.
across the board, everything that has to do with non-HIPAA breaches and non-HIPAA violations will be a non-HIPAA breach, because that's what we're saying under C.
Okay, well, let's see what others think, but let's Kelly show it as, yeah, go ahead and put that there, and we can come back to it as well. So that's a good, I mean, I hear what you're saying, so I think that makes sense. Pamela, your thoughts on that?
Yeah, and this might be the comment that's there. I think the confusion is using the word breach for a non-HIPAA breach, because I think you've added language to say if it's a breach under HIPAA, you're going to follow HIPAA, and then you're saying if it's a non-HIPAA breach, but using that word breach again, I think in the regulations we defined it as a non-HIPAA violation.
Violation, right?
I think maybe we need to change that all to violation so that we're not confusing breach, HIPAA breach. I think that's Dr. Suarez's point. Is we need to really make it clear that breach is a HIPAA breach and it follows HIPAA. A non-HIPAA violation is something different, and that's what we're defining in this section.
Yeah, and Kelly, scroll up a little bit, because I think to the point that Pamela and Walter just made, if you look at, I think it says 6A now, and it's scroll down a little bit to number 6. Keep going, keep going, keep going. 3, 4, 5. So here under 6, I think this is an illustration of what you were saying we should be doing, which says a description of a breach or non-HIPAA violation. Yeah, so we just have to make sure that that voice, that is, if we pick that up throughout, I think you're saying.
Yeah, exactly. I mean, because I think there, a description of the breach or non-HIPAA violation is, it gives the impression we're talking about a description of any breach or a description of a non-HIPAA violation. And so that is mixing the two.
Yeah. So Kelly, can you call that out, just to highlight it and put, a note that says, we need to make sure we have this kind of footprint throughout.
Yeah, and that's consistent, David, and it's because of the addition of B, where you've called out what to do in the event of a HIPAA breach. I mean, all the way up to the top. You've said if there's a HIPAA breach, you do X, and then we've taken the non-HIPAA violation, and then it goes down this whole path. So breach really shouldn't be mentioned after that first. I think it's B that says HIPAA breach.
Yep. Scroll up, Kelly. Let's just. And I'm looking closely.
Yeah, there it is. So it's B there. If any breach or violation is considered a breach under HIPAA, the notification process for that breach or violation shall comply with the requirements of HIPAA. And then C, it should be a violation.
Violation.
A violation is not a breach under HIPAA.
So we should take out the word breach. We should just say where a violation is not a breach. Exactly.
I think that helps a lot, yes. And I was looking at the definition of breach, and it is the definition of breach at the very, very top is the 45 CFR definition, which is the HIPAA definition. So
I think we're taking out the wrong thing, isn't it? Isn't it, Kelly? We should be striking where take out where it says where, then followed by a breach, or say where a violation is not a breach.
And we should take out references to breaches throughout this section, because we've already sort of said if it's a breach, it's going down a different pathway.
Yeah. And keep where, Kelly. Just take out a breach or violation. There we go. And then we have to make a note that we go through this section.
Well, no, you need to keep violation. where a violation is not a breach under HIPAA.
Yeah, that's correct. You just take out a breach or, sorry,
Exactly,
Kelly.
just a breach or.
Yeah.
And by the way, this is a big structural change, because even before 08, there is a lot of references to breach or non-HIPAA violation using the same context. So I think you almost need to look at all the places where it says breach or non-HIPAA violation and erase breach.
Yeah, so we'll add that, Kelly, to the comment. Check structural change throughout. That's a good point. Well, hello, Catherine. Comment? I think you're muted. And we can't hear you. You're showing muted on our end. Still muted.
How about now?
Oh, we got you.
Goodness, thank you, David. So I was going to say the same thing, and in terms of taking a look at the entire document, certainly the language breach and non-HIPAA violation has been used throughout, but now this makes me, and again, foggy is memory, want to make sure that if we strike the breach here and throughout, have we appropriately addressed all of the non-HIPAA violations in the section? Yes, probably. But have we lost anything specific to notice of breach that we do want to make sure we also state? So I think we need to check for that throughout too. We had a line item in here, right B, that actually said if it were obviously covered, under HIPAA, then, follow HIPAA. I don't know if that's enough language to cover everything once we strike that notice of breach terminology throughout here. So I really feel like there's some other sections that may have addressed this, and it needs to be fully reviewed.
Yeah, it's a great point. Thanks for the feedback.
Okay. Moving on then, the next edit we have is under, Kim Camerata.
Sorry, yeah, I put my comment in the chat because I think now we also may need to look at, how we're defining a violation then, right? So HIPAA is a defined term, and there are, other types of breaches that may not meet the defined term that we were trying to address here. So like Catherine, I think it's not as simple as just removing a term without thinking about everything else that may be lost in removing that term.
So, yes, Kim, thank you. But make sure I just comprehended your point. So you're saying we need to make sure the definition of a non-HIPAA violation is consistently applied throughout.
Well, I'm not sure how we're defined here. We're now going to potentially be left with a violation. I think in the above, when you scrolled up, you took out sort of breach and put in. Okay, I think Dr. Suarez is responding.
Yeah, this is the definition up at the very beginning of this entire document.
Okay.
10 for those of you who are on the document.
David, can I ask a more fundamental question? I feel like this confusion happened because of the addition of B, which is taking HIPAA breaches down a different path. Was there a reason for that? Because I think it goes to Catherine's point about if the policy purpose was to actually add more than HIPAA, we're basically saying for actual HIPAA breaches, you do less than non-HIPAA breaches. And I'm just trying to figure out what the reasoning for adding that B.
So let's go back. Let's go back up. And to be honest with you, Kelly, scroll back up. So to be honest with you, I can't recall at this moment. I cannot recall the justification for why. And if someone, maybe Catherine knows.
David, I'm just going to chime in. Walter, by giving us the definition from above, is helping my memory here. definition of non-HIPAA violation, but an inappropriate or use, access, maintenance, or disclosure of health information that is not a HIPAA violation, but is inconsistent with state or federal law. So the answer is we created more meat, right, in this policy within the state of Maryland beyond what is within HIPAA. So we created that container ourselves, and I'm believing that throughout the course of all of this data, we do have all kinds of non-HIPAA violations defined and expressed, and it's probably peppered in a bunch of these different sections.
Yeah, no, that's true.
And I really strongly recommend that we only use two terms: breach, which is HIPAA breach, and non-HIPAA violation. Those are the only two terms that, in my view, we should use. Because, and whenever we say breach, we really mean the HIPAA breach. And if there's any requirement that we are referring to only apply for non-HIPAA violations, then the word breach should not be there. If there are instances where we are looking at both requirements that apply to breaches that's in HIPAA and non-HIPAA violations that's in state of Maryland, then when we say breach or non-HIPAA violation, it really means HIPAA breaches and non-HIPAA violations.
That's
But
true.
if we mix the two, so I think this is a truly structural change across the entire document, trying to look for where do we mean breach as in HIPAA breach and where do we mean non-HIPAA violation, and just keep the two separate.
Yeah, no, that makes sense, because in the definition section, we refer to 45 CFR 164.402, which does define pretty much to what you both captured.
It's a HIPAA breach.
Yeah. So we'll make this a note. We'll certainly put in a note for our friends at Post and Shell to help go back through and take a look at all this. And I think there was a hand or somebody that I thought I heard something.
Yes, David, it's me again. I think so, to be clear, and yes, your team will take a peek at this throughout, but to be clear, Section 08 will then become notice of non-HIPAA violations. And so then the question will be for the team, is there a different section that is notice of breach that points you directly to HIPAA? Does it need more than that? But I think this section specifically then is now notice non-HIPAA violations only. Agreed?
I totally agree. Thank you.
Yeah. So Kelly, you wanna put that
I
in?
think that's right, David. And then, but my point is then, but then I think you have different, and that might be the reason, but then you have more robust reporting obligations for non-HIPAA breaches than you do for HIPAA breaches. And maybe that's the point. I just was making that observation.
Yeah, and my memory's a little fragment on it, but from what I can recall, Pamela, to your point, that's exactly what the stakeholders were seeking, because there was some general sense back a decade ago that that HIPAA was going to address a lot of the concerns, but where there were violations that weren't attributed to HIPAA, there needed to be a lot more coming forward as it relates to them. And that was kind of the logic as I reflect back on my memory from the past. Okay, let's keep moving forward. Good conversation. Thank you all for the thoughtfulness to this.
The next addition we have is G3, and this is circling back to our comments because this includes in the notification contact information and websites for credit reporting agencies and advice for consumers on how to protect their credit. So I think following up on the first conversation we had here, we can carry the comments forward, and I'll pause to see if anyone has anything to add. And if not, the next two edits are minor wording changes. So we changed medical record to health record as we have it defined, I believe, herein. It aligns with other edits I think we've made, but we can double check that. And then That brings us to the end of section 8, actually. So if we move forward into section 9, this is the registration and enforcement section. And the first set of changes we have are to A1, and these clarify that the applicant, being the HIE applying for registration with MHCC, it includes language specifying that they are a potential HIE as defined in Maryland law and the regulations. It also removes specifics about what will be included in the application for registration. So this provides some flexibility to revise the application as needed or as appropriate.
Dr. Suarez.
Yeah, just a minor detail. I'm not sure potential works here. I mean, the person is completing a registration for an HIE. It could be a real HIE or a potential HIE, but not just a potential HIEs, right? I mean,
Yeah,
in
that's
reality,
true. That's true.
so I would recommend, deleting potential. Just say
Because it's renewal. Yeah, let's just delete. I hear, because if it's a renewal, it's not potential. It's just an HIE. Adrian, your thoughts?
Yeah, I was going to say the same thing as Dr. Suarez. I think the HIE, you either meet the definition of an HIE or you don't, and there is no like potential HIE, right?
Yeah, understood. Other thoughts on what the strikeouts here, or we can keep moving? Oh, Catherine, you, and then Kim.
That was just a nod saying I think it's okay.
Thank you. Hey, Kim.
I was just curious. I understand the idea of needing some flexibility, but I'm curious to know why the ones that are being removed, are these things that you might choose to eliminate going forward, and that's why they're eliminated here? Like, what's the reason?
So in short, the constraints that were added to that A through F presented doesn't allow for flexibility. And what we encountered from HIEs in the past is that there's some areas of flexibility that need to be enabled through an application process, which is nimble, as opposed to putting it into a structural sense of a regulation. And we created a lot of headaches for HIEs that in the end, we still couldn't get information from. So, so what we wanted to do was use the application process, which is how we handle other activities here when it comes to registration. We put it in the app process and we put it out there so stakeholders can see it, and that covered entities that might be affected have a chance to weigh in.
But David, that actually didn't answer the question. So one of the things that was required when originally drafted was that the applicant has to show that it has the technical capabilities, right? So why would that not be a basic proof point? Similarly, what was sort of the problem with providing a registered agent?
Well, we wouldn't necessarily take it out, but we would keep it nimble, because in some instances now I can't recall the exact incidents, but in some incidents a registered agent didn't make sense, and it wasn't achievable, but it didn't hurt the organization because there was other controls in place. And I'm sorry, I can't remember specifics, but that was one where we ran into a lot of challenges with organizations, HIEs. So I guess what I was trying to say, Kimberly, is that we're not necessarily saying that these aren't still going to remain in the application, but it gives us a possibility that if they don't apply, it doesn't become a barrier to an entry for an HIE. And to some extent, that's what it does, absent if we keep it in the reg.
I understand I understand the goal. I'm not sure I concur with the result, but we can certainly address that in later comments.
Understood. Walter.
Yeah, I mean, my sense is what this is doing is saying whatever the commission decides, or in the form and manner specified by the commission means the commission now has leeway to incorporate all these elements, and if something doesn't apply, then permit the application to move forward.
Yeah, that's
and not being so prescriptive in the regulation as to almost micromanage the entire application process with the specifics of the content.
yeah, and that's a very good point. We run into problems in decades past. I've been here now over 2, when it's so prescriptive that sometimes it's barriers to entry. Other times it's just it's not nimble enough where when there are changes in the industry, you can capture either some more of something or less of something or something different but important to capture. And because the application is so structured, it creates headaches, or impossibilities, I should say.
So another way to achieve that would be to keep all these A through F, but say instead of that shall include, say that may include, and then have this list. So that gives you the leeway, but at least the states which are the
let's highlight that, Kelly, and just put a comment there, because we tend to think of the regulations as being more shalls than mays, but
I understand. Yeah. Oh, it was just a way to reconcile what Catherine was suggesting.
Understood. And I think Catherine's still waiting to make her comment.
That's okay, Dr. Suarez. That's what Kimberly was mentioning. I was going to
Kimberly, I'm sorry. Bill, yes. Yeah.
That's okay. That's okay. I was just going to say, I actually think the goal here is to have whatever the commission requires in the application be appropriate, and the general app, the general nature of line commission app, whatever it is, and the flexibility of changing, I think is perfectly appropriate. Anytime we can any specificity that shall be included in any type of written response, report, application, I think it's important to remove it from the regs. It's constraining. We've gotten in trouble doing that in the past.
Okay, thank you. Let's keep traveling on. Oh, I see. Matt, your question. I think you had your hand up earlier and we may have skipped over you. My apologies.
That's okay. But my question goes to the registration. You had mentioned renewal. Do we need to specify that this is for registration or renewals?
Interesting. So a person completed an application for registration. So let's put a note out there, because I guess you could interpret it 2 ways. Registration is defined as the first point of entry, or registration is when your current registration expires, you have to register. So I don't know whether we need to call that out specifically, or is it just always registration? And if the app says registration period is for 12 months, then aren't you registering? So I think we'll put a note here, but it's a good point.
Okay.
Okay, Alana.
Then moving down to section 2, financial integrity. We've done a bit of rewording in A to align with the removal of the specific application requirements above. And then in B, we've added specificity that the information about the applying organization's financial integrity, if it's requested by MHCC, that it is based on the current audited financial statement instead of just saying the financial statement.
Okay.
And then continuing on, still under the financial integrity, just a minor wording change, clarifying that corrective action is meant to improve privacy and security of PHI as opposed to repair. And then underneath that in E, we have an addition to include language to specify that a balance sheet and income statement requested by MHCC should be prepared by a certified public accountant. Then in the next section, in 3, there is some language edited to specify that the information received is a complete application submitted to MHCC by the applicant. So instead of saying complete information, just making it a bit more specific to say a complete application. And under that, another wording change. So where it says deny the, oh, go ahead, Dr. Suarez.
Yeah, no, I don't know if you were going to, I'm tracking, but on B, it does say renew every 2 year the registration. So to the point that was made about renewal, there might be a need to reference the renewals up there as well, registration and renewal.
Yeah, good point. Matt made a good observation. I think Dr. Suarez, your point is good too.
Yeah, so in B overall, the edits we see there changes the timeline for renewal from every year to every 2 years. Hearing no comments regarding that. Continuing on.
Oh, no, I couldn't tell. Catherine, were you going to say something?
No, I was just, again, if we were all in person, you would just see me chuckling that I don't know that any HIEs certainly or other, stakeholders of HIEs would do anything. They'd be delighted to say you've only got to do that renewal every 2 years, right?
Yeah. And staff would say very much, yes, every 2 years.
All right, and then also within B, we've removed the specification for registration tied to the fiscal year calendar. So removing that requirement for being within 120 days of the close of the organization's fiscal year. And then the next edit we have just removes the requirement to provide the results of an audit, which is in line with the edit above where we removed the specification for what would be included in the application. So this is aligning with that change.
Kim.
So let me see if I understand that. So the audit won't be required every 2 years. Is there a thought of at least maybe requiring an attestation of continued financial solvency?
Hold on. Where did we, can you point me to the specific citation section you're referring to?
Alana just mentioned it on sub B2 on the screen.
Results before. Now, scroll back up because now I'm confused. I don't think we were saying the audit's not required every 2 years. It's part of the application, so it would be required. Isn't that, Alana, in application?
I think that's why it's so important to say renewal. I mean registration or renewal, because that's,
yeah, but it should be in both. I mean, where did we take that financial statement provided by EG? The following review. We may just have to put a note because Kimberly, your point is right on. We don't want to, I mean, lots can change in the financials, sturdiness, if you will, of an organization in 2 years. So we wouldn't want to skip that.
yeah, I mean, it's part of the elimination of A, B through F on the registration. B is the HIE's current audited financial statements.
Yeah, but we've just taken it out to Catherine's earlier point. We've just taken it out of the app. Out of the reg. We weren't saying that it's not required because it would be required.
Then it should be in in the list of requirements, because if it's something that should be required, you never know who's going to be in charge at MHCC in 2 years
That's
or 4
true.
years, who might decide, we don't need that financial.
Yeah,
statement.
so let's scroll down under financial integrity and let's just make a note under 2. Yeah, about the requirements, because we've taken out financial statement, a following review. I think let's just look at, we probably shouldn't have taken that out, but let's look at where we've taken out the review of the financial statement provided. Because I think that's, that won't change.
Yeah, right now by taking it out there at the beginning and then here on the renewal, right now, basically it's left to the commission to, in the application process, include it without being named in the regulation. But just
Yeah, and I think because of the nature of the importance of it, I think Kimberly is saying that's one element that she would propose that we leave in the regulation, and I think that's probably not a bad idea. Unless Catherine tells me it's not a bad idea.
No, I agree with that as well. But I think the question is to do the annual audited financial statement submission. Does that mean you also have to do a, registration annually as well?
No, that I think we have to. I think the assumption is if it's biannual, it's whatever your most recent year is. So it's the second year or whenever the application is submitted, it's that annual audit.
Right. And I do think that's important to include in the reg as well.
Yeah, it's a good catch.
I vote for it to be included as well. I think that's important. Thank you, Kimberly.
Good comments. Appreciate all the feedback.
Okay, then moving down to B4, we've just added the wording may be to make it clear that MHCC may request additional information. They also may not. So adding the wording there to make that clear.
So do we need the words maybe? Isn't the word just as requested? Isn't that enough? And I yield to the attorneys on the call. Pamela, what do you think?
I mean, I think it's duplicative. I don't think you need the maybe. I think it's implied. It's
Yeah,
the information requested is if it's requested. If they don't request anything, you can't provide anything.
right.
I would agree with that, although I have to say, David, to your comment about most regulations are about Charles, this particular one, I checked and there's 121 mays. So just
Listen, if you keep this up, Dr. Suarez, we're going to unvote you. We're going to vote you off the island here.
no, I'm just kidding. But no, I think that we can get rid of this one and then you'll have only 120 to look into.
Fair enough. Note to self, make sure his name comes off the list next month. Just kidding.
No. Okay.
We very much appreciate this. This is all good. This is all good.
Okay, then in C, we've added or HIE specifically as it would apply to an organization after becoming registered as an HIE. So this is about the commission taking an enforcement action against a person, and then the addition is or HIE.
Pamela.
I guess maybe I shouldn't ask this question, but who's the person if it's not the HIE? Like, or is MHCC really going after an individual?
Thank you.
I guess I kind of assumed that by person it meant HIE. So now I'm confused as to who the alternative is.
So person is a defined term, which I can pull.
I just meant more practically speaking, like who is the MHCC going to have enforcement action against at an
Yeah, no, it is the organization.
Right.
It would not be at the individual. So But I think do we define person in here to mean, and I'm looking to,
Yes, I'll drop it into the chat.
because it could mean,
It doesn't include the terms HIE. It's a traditional legal phrase, right? Individual, trust or estate, general or limited partnership, joint stock company, unincorporated association or society, et cetera, et cetera.
I guess my point is broader, which is what enforcement authority does the MHCC have under these regulations beyond HIEs?
well, so the answer is the regulations we don't specifically think of it as, in terms of enforcement, being the individual. So that's an interesting question. I guess we have to come back to, because states or political subdivision of the state or any other. But we use. I think we're missing something here, because I think there was this whole long reason why we did include person, as opposed to just the organization. And I think we have to go back to look at that. But I don't think you can. I feel like we couldn't simply not acknowledge the person. There was something about it, and I don't. Maybe Catherine, you remember the history of it better from you've been around since I have on this.
Actually, I don't, David, but I was going to ask if we could perhaps see the definition that we have in here of HIE, because I'm vaguely remembering that I think at the time we thought this definition of person might in fact be an umbrella over HIE, but now I want to see what that HIE definition, to see if somehow there is two separate distinctions. Right now the time has passed, many years has passed.
Yeah, page 9, if you want to scroll back to page 9, bottom. So it pretty much looks like it follows what the common definition. It would be number 20. Okay.
Yeah.
But
So
that's
that,
right? Was that revised from, to Catherine's point, I think originally the definition was more of like, HIE was the infrastructure. And so I wonder if you had to add person because you needed to get at an entity. And now that HIE is defined as an entity, is it sufficient to just say your enforcement action will be against an HIE?
Well, the thing is this, if you go back to page 41 at the very beginning of registration, part A says to operate an HIE in the state, a person shall be recognized by the commission as having met the requirements for registration. And then from that point on, it gives the impression that that person that was recognized by the commission for the registration will be potentially the person that will be subject to these actions.
Either the HIE or person. Let's just note this, and we'll get our strong legal teams to look at this to make sure we get it right, because I feel like it's both. But yeah, I feel like it's both. So I'm not sure we can solve it or give you much better answers than we have at the moment, other than we'll bring this to their attention.
I think that's a good suggestion, David, because again, as time passes, we have established, the person, we've established HIE, and it might be sort of more of a blending now today in like modern lingo. So that could have, to Dr. Suarez's point, that could have another ripple through effect potentially through the whole document.
Yeah, so we'll have to come back to that.
And there are 71 references of person in the document already.
Good case in point. But who's counting, right?
Yeah, it looks like I am only. I'll stop counting, but yeah.
No, this is good. We're just a little levity for today's a Tuesday. Yeah.
All right. Then moving on to the next edition, we've just added the language by the commission to specify that MHCC is the one granting the extension to submit an application or supporting materials. And then the next, so I'm seeing, so still on page 43, Kelly, maybe a little bit ahead of me. There we go. So the addition there in B, where we've edited the wording regarding enforcement action that could be taken by MHCC following an investigation. The MHCC may issue a notice of proposed action. So wording change there. And then moving on to D, in line with above, the addition of the HIE, so we can carry the comment forward if there's nothing additional there. And then in 2, below that, we have included, kind of in line with, but included specifically a representative of the HIE instead of just saying or HIE. And then if we continue down to E, we've added wording for specificity to align with the requirements below in 1 through 6 regarding a notice of proposed action and an exception that the recommended decision not be adopted. So if we, it may be helpful also to reference C above regarding when a proposed action is not resolved. So this is kind of specifying a written statement of exceptions in that instance where there was a proposed action. Okay, and then in 6, we've included a requirement about what will happen in the event that no written exceptions are filed following an unresolved proposed action in hearing. Okay, and then moving down to G, where we talk about exemptions, we removed the time constraint on the period for exemptions, but so we've removed it from 1 here, but then we do reference a timeline specification in 5 below. So it's just moving the timeline from 1 where it says an HIE may request a 1-year exemption, and then we'll see a little bit further on where we include in 5 a timeline of when the exemption would be reviewed.
Hey, Kimberly.
I think Catherine was first.
Oh, my apologies.
That's right, Kim. You were probably going to say the same thing that I was, which to the extent that we're mentioning, again, the word renewal, application renewal, we need to make sure that we're consistent with the application versus or application renewal terminology from above.
Good point. Good point. Kimberly?
Yeah, no, and my point was, and I've never been very comfortable with this idea of exemptions from requirements, particularly continuously renewed exemptions. So I know that this is, largely sort of just a reworking, but this has always been a concern that we've had.
So because the models are different, for example, the HIE that Audacious Inquiry operates is completely different than, say, the HIE that CRISP has. So there are just some requirements that aren't workable for both models. So I'm not sure how we could approach it if there weren't the room for some exemptions. So is it just the whole notion of exemptions, Kim, or am I missing what you're really saying?
It's the notion of exemptions from certainly certain provisions, right? So, I mean, we used financial solvency as an example, right? I mean, I would think that there would be certain baseline requirements that one would have to meet no matter what the model.
Yeah, but couldn't the commission, I mean, you would just would you not be approaching it just from the other direction if you said you have to provide all this information if you want an exemption, and then the commission could say, no, doesn't meet it, so you don't get, there's the exemption denied. Aren't we approaching it from a different angle, but yet making sure that we don't box in models that couldn't perform or couldn't complete certain tasks?
Yeah, and I guess maybe it'd be helpful to maybe know what some exemptions have been requested over the years, right? And then they put my mind at ease. But this has just always been a bit of an area. So
yeah, and I think the other uniqueness comes from the software developers who are HIEs, that operate electronic health record systems, that because the definition of HIE is broader than just the traditional brick and mortars, they run into some significant challenges with some requirements that a traditional HIE could perform. Dr. Suarez, you were going to note?
Well, yeah, I was trying to understand if we're talking about exceptions to the general registration application or exceptions to the possible commission enforcement actions.
So, well, they both one are the same, right? If there's an exemption from the application, it would be exempted from enforcement actions.
Yeah. So I was trying to understand if the exceptions were exceptions about the certain elements of the application, or exceptions about meeting certain requirements, or exceptions about reasons why the commission might take enforcement action against the HIE. I mean, there's different groups of exceptions. I'm not sure which exceptions are we referring to here.
So the general section is on the general the registration process. I'm pretty sure Alana could correct me.
Yes, so section 9 in the registration process.
Yeah, so that's where we would be focusing on.
So this might be, I'm just trying to understand an example of an exception, might be exempting someone from including a copy of their audited financial statement?
It could be, but I mean, it could be. So it's hard to, without we're dealing with examples, so I would say it could be.
It could be any component of the application.
Right, it could be like naming a resident agent. Why would you name a resident agent? What would be the circumstances? What could be, why would you want, a financial statement? And I'm making stuff up here, guys. But if you're a software developer and you're selling your product, it's not cloud-based. It's actually hosted at the site. Maybe you wouldn't need to have a resident agent because there wouldn't be a requirement for it. So I'm just giving really off the cuff examples. I'm not suggesting these are examples.
Yeah, E2 is the one that is confusing because it says exceptions shall specifically identify in writing each finding and conclusion to which exception is taken. So I was thinking that this was applying really to something that the commission was deciding on, or an action that the commission was taking against an HIE, or I don't know, but it might be just my confusion, and if others understand well, then I'll just go with it.
Catherine.
Not speaking like an attorney, and I do feel some empathy for why Kim does not love exceptions, but in the same kind of conceptual reason, we said that the commission will have an application and we're not going to specify in the regs what shall be included in it. For that same reason, I feel like the ability to have an exception, certainly to encourage the creativity and model types that may not all to a cookie cutter, I'll call it application. I think we should also certainly say that the commission can create an exception. And I like that it's to put the teeth in it that maybe Kim at least is looking for. It must be in writing. It's going to be, publicly available information. It's in writing, the reasons why, et cetera, et cetera. And if it's unreasonable, I would like to think that it would not be granted. If the exemption is reasonable to foster innovation, for example, without risk, then the exception would be granted. It would be well documented, and I would be comfortable with it remaining as such.
So Catherine, are you supporting because it's in 2, you like what's in 2 and you think it works? Is that what I heard you say?
Absolutely. I think it's an exception, but it puts some teeth into what and how you're able to get an exemption. But I think the authority goes back to the commission to grant it or choose to not grant it. Understood.
Thank you. Adrian, your point.
I was just gonna I asked my question in the chat, but I just want to, so not a lawyer. I think it's an exemption to the entire chapter, right? So it's the entire set of regulations that an HIE can apply for an exemption for, not just what's required in the application. So we can't comply with this section of the regulations. This is why, and then the MHCC can decide if they're going to grant an exemption to that regulations. And I was going to ask the question, but Catherine stated it. Are those exemptions publicly available? Because that's what I was looking for, that maybe that would provide some additional comfort for Kim, is that, what kind of exemptions is the MHCC granting?
Yeah, so the short answer is unless it's marked, something is marked as proprietary and confidential, it would naturally be publicly available. But if it's marked private, if it's marked proprietary and confidential, there's a whole review process. And there is one other situation that I'd have to ask our AAG to talk about that can enable something to be proprietary and confidential without it being marked that way. And I just don't remember at the moment. But typically, it's either easily accessible because we put it on our website, or it's through a PIA that you can get that information. So it seldom is it deemed proprietary and confidential. And there has to be some strong, compelling reasons. Kim.
Without waiving my objection to having exemptions to a licensing scheme, I did appreciate Catherine's commentary that the language doesn't exist here with regard to, exemptions that would, foster innovation without risk to the healthcare consumer. I mean, perhaps if there was at least some comforting language in there at a minimum. Because as I read it, there's an exemption can only be made on the following grounds, one of which is the absence of certain functionality in the infrastructure that doesn't allow the HIE to maintain compliance with a requirement. Taking at its extreme, we really can't prevent breaches because we just don't quite have that functionality yet. I know it sounds absurd, but again, we never know who may well be making these decisions at the state level. And, so at minimum, you've got to, there should be language in there that discusses why on earth you would allow it, and that it would have to be, without risk.
Yeah, fair enough. That's a good point. And I hope you don't know something that I don't know.
No, it's just,
Anybody need help? I understand. Dr. Suarez.
Just a quick question. Does the state law requires to allow for an exception? Is that where this is coming from, or is this something that it's...
So in our statute, we don't use this kind of language. We say we defer to the regulations.
Yeah, no, but in some cases, the statute defines, certain things about the
That is true,
program.
but not in our HIE statute.
So the HIE statute does not explicitly,
We talk about the regulations. We refer for regs and for this sort of thing.
and the other point is, in many cases, regulations actually cite the authority in the statute that defines where the regulation is coming from.
That's true.
So that's why I was asking if the statute defined anything about exceptions. Because if it doesn't, then what it means is basically the commission is the one that is recommending to open the door for exceptions.
Right. The commission, yeah, right. That there has to be, I mean, when 20 years ago, we recognized there has to be, regulations have to be flexible. And so that's why some of this is as you see it today.
And Sandra Connor, Reverend Connor, I see your hand raised.
I was just raising my hand to agree with what Kimberly said, and anyone else who's waiting to think that there needs to be a positive insertion of something to qualify what the exemption should be. I agree that we should not leave the onus on someone down the road when there's transition to make that decision. So I think there should be a positive statement of some sort to protect the consumer
Understood.
and anyone else.
Thank you, Dr. Connor.
Great, thank you. In G3, we have added language specifying that the MHCC will provide written notification of the following actions. And then it goes on in A to include additional specificity for granting of the exemption to include as requested or grant the exemption for a modified period of time. And then also including just a rewording there around, with an explanation as opposed to providing written notification in the event of the denial of an exemption.
Okay.
Okay, and then G5, we have just included the word only. So an exemption may be made only on the following grounds. And then G6, this is where we include some language, and this revises the process for extending an exemption. It lengthens the timeline for renewing an exemption to every 2 years instead of annually, which would also align with the revised renewal timeline.
Okay.
Okay. Hearing nothing, then that sums up section 9 for us. As we go into section 10, which is requirements for accessing, using, or disclosing data through an HIE for secondary use, this section has fewer proposed changes than others that we've reviewed so far. It mostly covers population care management and research as secondary uses of PHI or health data. And so the proposed changes address enforcement and reporting in section C. So if we scroll down a bit, and it's a couple of pages there to C2. So under the enforcement and reporting here in C2, we've added specific minimum requirements for what will be included in a summary report to be made available to the public on secondary uses of data. And
Yeah.
Yep, go ahead.
Your thoughts?
Sorry. So the number of requests for secondary use, does that include requests that are not honored? Right? As the expectation that anytime a secondary use request comes in, that CRISP or another HIE says, no, we're not able to give you that information because it doesn't comply with the regulations or it's not in comport with our participation agreement, that we would need to make that publicly available?
Yeah, that way, I see where you're going with that. It certainly reads like that's the intent, but it shouldn't be. So I think we need a qualifier.
Okay.
Yeah, it's actually what's highlighted. Quarterly, see where it says the report shall include added blah, 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 the number of requests. I think it's the number of requests, for lack of better words, that are honored, but we'll have to find
Right,
out.
that are honored or fulfilled or something to that nature, but not just the number of requests, because that's a lot.
And I think there's another question somewhere. Did I miss that? Dr. Suarez.
Yeah, I mean, I think an overview is not very explicit about what is it that needs to be provided. I think in other places, in other states, what they provide is actually who the data was given to, what data was given to, for what purpose, and the extent to which the data will be, used, a time frame. So I think it's very important to know in this question about overview, who's the recipient of the data, what is the data and I know it said the amount of data released, but and then what is the purpose of the release? Those three things I think will be valuable.
So that's very granular. That's kind of a departure from where we have been. So maybe I turn back to some of the folks that have been on this group the longest, Sally Ann or Catherine, or those have been around a long time, because I feel like there was a reason why we went to summary reports as opposed to being too detailed. And I remember these conversations at length, but I just don't remember what was the driver of it. And I don't know if anybody else does. And too bad Tom Lewis is not around here, because he feel like he's one of the folks that were spearheading Dr. Lewis's conversation. So maybe I ask it this way: does anyone have any concerns about the level, about being more granular, and as opposed to being, high level summary information? And Pamela.
I would just be curious to know how frequently these reports are accessed. Is this really like a valuable tool? Is this something that the healthcare consumers really want? And if it is, then we should talk about maybe making it more granular. But if it's not something that's accessed very frequently or something that's requested very frequently, I just worry that we're asking for more granularity without much value.
Yeah, and I can't recall any HIE, and Adrian, correct me if I'm wrong, I can't recall any HIE that's has had this kind of information requested. I just don't recall, particularly for CRISP, and maybe Rob's on the line as well, can share his thoughts. Or I think we have Michelle Burrow here too somewhere. Or Sally Ann, your thoughts? I mean, I just don't remember seeing this happen a lot.
So I think I'll start. So at CRISP, we post all of the use cases are posted to the website when they are very specific about who has access to what data for what purpose. So I think for the majority of the use cases, CRISP meets the requirement that Dr. Suara was suggesting, except for and I don't do a lot of the research use cases. I think the majority of the secondary use requests that CRISP does honor, because I already outed us and said we say no to a lot, but they are research uses. And I don't know if maybe somebody who knows more about research, if there would be a concern from the researcher's perspective for us to post too much specific information about a research study. And so maybe that was the reason for going to the summary reports. But I can't remember it as well. And I've been sitting on this committee for a long time too, David, maybe another context, but.
Yeah, Adrian, I as I recall the discussion, and there was a lot of it, is I think the decision was that for public consumption, as a routine report for public consumption, the summary information was be sufficient. And if anybody wanted anything more granular, then they could make a request and get the information. And I think that's where we were going. I don't particularly remember being concerned about privacy for the researchers in particular, but I think that's a good point too.
So, so then I guess Sally and then going back to Adrian. So could we support the more granular and just and then have some kind of statement that speaks to exceptions to that, and maybe those exceptions are determined by an HIE's, I'll say, privacy board or IRB or something like that, where it's more research oriented, that we're turning to a committee to look at whether or not it would have impact, a negative impact on the work or the individuals if that were released.
I just think a summary report is sufficient with a statement, that says, if additional information is required, make a request.
Okay.
First of all, the public in general probably isn't going to be that interested in this. There will be, whoever is interested in more detail is going to have a specific reason for doing it, a purposeful reason.
Okay.
Well, in many cases, the ones that are interested are not necessarily the individual, the individual consumer, but actually the participants, the participating organizations that would be interested. And they should be able to request that information from the HIE.
Yeah, I agree. I mean, like, again, put the summary out there, and if an organization or whomever wants additional information, request it.
So, but then we need that language there.
Yeah.
So, Kelly, if you want to note that for addition for 2.
I mean, I would make it just, something simple. Requests may be made for additional detailed information.
Fair enough. We'll let Sally in. We'll have to come up with a different word for may, because Walter is.
No may. Yep. Organizations shall, Walter.
Okay. We shall. We definitely shall.
Very good.
Entities.
Thank you.
I hear for a hand, Alana. I'm not seeing him.
Louise Pearson.
Okay. Yes. And then there's
Catherine.
And then Catherine. Yeah. Okay. Louise, please.
Yeah. I'm just, when you talk about data, I mean, it's not a defined term. So I'm trying to understand, does that just mean PHI? Does it mean de-identified data? Is that something, like EHRs frequently are sending that information to insurers because there's, agreements amongst the providers and the patients that the information go to insurers? I'm trying to understand what this would mean for us.
So, there are many terms that aren't defined that I think have pretty much, a strong working knowledge. If everybody were asked to define the word data, they'd probably come close, but I don't think we define what constitutes data. And I think that would be hard to, because that's if you made it inclusive, then boom, something could be missed.
Well, but see, like, we have consent to de-identify data, and we use that de-identified data for many things. And I can't imagine that we would have to provide summaries of that.
No, I don't think that's what we're aiming at here. And I wouldn't have thought that. So others help me out, because here we're talking about requests for secondary use.
Well, it is for secondary use. Various people use it for research purposes. Insurers use it you know,
So restate the concern, because we may have to take this away and have discussions with you know, the folks at Post and Shell. So can you just restate your concern again?
sure, we have consent from providers and patients to utilize their data as long as we de-identify it. So we have, you know, banks of de-identified data that various, you know, companies want to utilize for various purposes. You know, insurers might want to utilize it. You know, various other organizations might want to utilize the de-identified data. And researchers, I mean, the FDA, the CDC, I mean, there's all sorts of different people who utilize that de-identified data to like try to track diseases. Pharmaceutical companies use it to try to see whether or not, you know, specific, you know, they can pick out specific diseases and treatments. I mean, but it's identified data.
So I think, we have a definition. So maybe what we're meaning is secondary is really de-identified data, because in the definition section, we have that definition, oddly enough. I'm just trying to see if we have secondary. Maybe I missed Walter Truckler. The fast fingers to do a search. Do we have, you see secondary data defined? Yes, secondary uses of HIE data, we do. Means disclosure of access, use or disclosure to HIE that is not primary use data.
Yeah, it's not ATV.
Yeah, so we need to do a little work, because it doesn't, I think the intent was for de-identified, but we'll have to do some work here, because I can't. You bring up a good point, and I don't know that it's easily fixed by a word change.
So I see Catherine and Adrian both have their hands raised. Catherine, I believe you were first.
Thanks, Alana. I was just, David, to your point earlier, going to say, here's what we need Tom Lewis, because I think he would remember some of this. And to Adrian's question around, could this have been for visibility for research or something? We had lots and lots of conversation on secondary uses, on research and how to separate and address both of them. And having not read this through to the end, I'm wondering if we've not yet gotten through all the relevant information that may actually help inform this particular section as well.
Yeah, it's possible. So we'll, you know, if it's not marked with a change, we'll come back to it for certain, working with our attorneys, both at Post and Shell and here at the state, just to make sure. And maybe we can recruit Tom for our next meeting.
There we go.
Okay, I think, was it Adrian or Dr. Suarez? I don't remember.
I think it was Adrian first.
Okay.
Thanks, Dr. Suarez. So I was just going to kind of concur that it would be nice to take a relook at the secondary use regulations, because to Catherine's point, you know, there was a lot of conversations about this at the very beginning, and there was a lot of concern from patient advocates and others that the HIEs were going to be using de-identified and other data and be, you know, selling data, using it, allowing it for marketing. I specifically remember having conversations and as a patient advocate and thinking, you know, patients aren't going to want their data sold to marketing firms and then having people calling them on the phone trying to sell them medications or other things. And so I think, you know, we did lock these down very tightly for a really good reason at the time. And maybe there's still that strong reason to have secondary use defined the way that it is defined. But I will say it does make it a little difficult to operationalize when we define secondary use as anything that isn't primary use, because it doesn't really perfectly align with HIPAA. There are definitions there are things in HIPAA like organ procurement organizations, which aren't treatment, aren't payment, aren't really operations. They have a specific exemption in HIPAA. So are they defined as secondary use? Because it's, even though it's, you know, maybe more public health. So I do think if there's a way to kind of have a more nuanced definition of secondary use and what we're actually trying to protect, which I think is still that selling of patient data or the use of that de-identified data for something outside of really impacting or improving patient health, meeting the triple aim. So I do think there's definitely some room for improvement in the secondary use, especially as the Maryland Department of Health and HSCRC and others are really trying to move their population health goals forward. These regulations are very limiting in terms of, being able to do that. And so I don't think it's all about the research. I do think that is one bucket we need to think about, but there's other stuff to also be thought about. So maybe, David, as you're thinking through them, keeping that in mind as well.
Excellent point. And I see Steve Fox taking copious notes. So we'll be talking to him offline about this.
Okay, then we have Dr. Suarez and then back to Luis.
Yeah, I just wanted to make a point that we're talking about two very different concepts here. The question about what is data and the question about what is secondary use. So I was looking at data, and in the previous sections, because this is about data for secondary use, point 10, section point 10 at the beginning of page 46. For population health management, it says an HIE may disclose de-identified data or a limited data set. Yeah, I mean, it doesn't say, protected health information or PHI or IIHI or anything like that, but it's those, they may disclose de-identified data or limited data set for purposes of population health care management. And then under B is research is exactly the same thing. HIE may disclose de-identified data. Actually, this one doesn't even say limited data set. And so this section C, enforcement and reporting, does not qualify what type of data is it that we're talking about. And I think, to the earlier point, I think that is going to be very critical to establish under C. First of all,
Yes.
an HIE may disclose de-identified data and for reporting for secondary uses and for enforcement and reporting purposes. These are the conditions. But
right.
it needs to be clearly defined, because I would be we're talking about very different things if we're talking about disclosure of de-identified data, disclosure of limited data set, or disclosure of PHI.
Yeah, so it doesn't tie back to A and B. There needs to be some. It's a good point. So Kelly, just note that we need to look closely at A and B here. Thank you for that. Did we miss anyone on this section?
Louise has her hand raised.
Oh, yeah, okay. Sorry about that. Go ahead.
Yeah, I know. I just wanted to say, I'm trying to understand what your objection is to the use of de-identified data, because we would have had to have gotten consent from, the patient and the provider to utilize that data as de-identified data. And then, of course, you have to have an actual opinion from someone, a statistician, saying that data can never be, reconstituted to identify the individual. So I'm trying to understand what your concern is there.
So I think everybody's saying the same thing. It's just, how is it expressed? Because I think what I hear Dr. Suarez saying, and what I hear Adrian saying, is that it's not clear. So in absence of clarity, you get confusion. And I think you're making a point that there is a process, but it's just not, and that's very true. So there has to be some recognition of the expression here.
Right. But I'm trying to understand, are you saying that we would have to provide a summary of every use of de-identified data, or are you saying that maybe we want to exclude de-identified data from
Well, I think so I think it's we want to have exclusions, because I think that Dr. Suarez is talking about, research is different than, which is B above, and research is different than A. So I think we're still saying the same thing. We're not saying that, there's population care management that uses a different kind of data. It uses more aggregate data. So if you're releasing information about, you're saying, well, this is the purpose of well, this was what a summary data of aggregate information that is released, and there's research, which, as you pointed out, that requires a whole litany of consents. And I think what some are making that Adrian made around confidentiality, you don't want to, the consumer folks would be very concerned if you had too much granular information about what's being used in research. So I think we're still all saying the same thing. It's just how we need to articulate it here is the question.
Yeah, this is almost like a table you have to create with the 3 types of data and the types of secondary uses. And, it's almost like, what kind of reports do you generate or expect to be generating based on if it's de-identified data and it's for a secondary use like research or, general data analysis that is not tied to treatment, payment, or operations, then the report could be a high level, or there could be maybe no report. I don't know.
Right. I mean, why wouldn't we just carve out de-identified data? Because it's not.
Yeah.
It's not.
Yeah. No. Fair. Yeah. Fair
Exactly.
enough. Absolutely. So I mean,
Absolutely, I agree.
And under research, that's. Yeah. I mean, again, I think we're saying the same thing. We'll work with Steve and team. And I think we can get to the point that you're saying, or close enough, where just some tweaks would be all that's needed. Sally Ann.
I think maybe now I'm getting confused because, I mean, if you eliminate de-identified data, then basically what you're saying would be a summary report of identified data. And the only use that we have for identified data is ATB. So,
see, I think we're getting tripped up over the word data.
Yes.
Because we're not talking about elements of, we're talking about it in totality. So request for data for secondary use. What did I requested that, and I'm picking on population health, the number of, so company X, and I'm making this up, but just for illustration, requested the number of people that had hepatitis or some reportable disease in some specific area that met the requirements of HIPAA undersize. So that's a secondary use. It's intended to be, it's aggregate because it's for population health. It's not identifying the individual or linking it back to them in any way, but it's of a specific element of data that's a reportable disease under state law. So that's the kind of secondary population health that was conceived of when this was put together. It wasn't, okay, here are the specific, the 10 data elements we want from a database. And I think that's tripping us up.
Yeah, because I think when we said summary, we meant summary.
Yeah.
I mean, just, really just, there was a request for X and it was for the purpose, it was one request from X entity for the purpose of research on October 14th.
Yeah, it's so, but I do hear that we need to massage this a bit more.
Yeah.
These are all good points. And
yeah, I just wanted to make sure we were, not getting too far afield and making this too complicated.
Yeah, no, and there's a few hands. I may have missed the turn. I may have missed the sequence. I think Lee, did you want to weigh in here?
Yeah, I was actually after Kimberly. I don't know if it matters.
Feel free, Lee.
Okay. I was just going to say, one thing I think we need to keep an eye on is burden on the provider organizations. I mean, every report you guys, say, well, this is just this number of data points or just this or just that. I mean, they have so much reporting to do. And I don't think we should be blithely adding another report without thinking that through. The other thing is I would push back a little bit on what the purpose of that report is. So why is the state of Maryland trying to track these requests for data for secondary use? What is the purpose of it? How is that going to be used? And, you know, I say this everywhere. I mean, what's the purpose of a report? There has to be some benefit. Something's going to be done from it. Some value will be derived for public health or for whatever. And I'm not sure I see this, particularly where you do have the patient and the provider having provided consent. They've agreed. Everyone's happy. You know, what's the purpose? So I am not sure I see that here.
Yeah, I mean, there's some of those are good points, Dave, but I would note that the state isn't tracking this. This isn't information they're giving to the state. This is just information that they're making available to the general public. But I think your points are sort of what we're saying. We got to go back and work on this section a little bit.
Yeah, and if particularly if it's just for the general public, I would really say who's going to pay attention to this and why do we need to do it? Because it is going to put a lot of burden. Particularly, you look at the large organizations who get lots of requests. You know, think about Johns Hopkins or whomever, right? I mean, that could really add up and be a half of an FTE. I mean, who knows?
Yeah, and are we we may even be saying, which I don't know, that maybe this section, it doesn't belong. I mean, maybe we don't need to have this section. If an HIE is choosing to make this available, then they can do that. But maybe it shouldn't be in reg, but I don't know that we know the answer here. And I would suggest that we strip it out. But I mean, that's kind of what I think some of you are saying is just there's nothing that prevents HIEs from doing this kind of summary reporting, but does it need to be in reg? I don't know. We'll have to, we need more thoughts. So Kim, what are your thoughts? And then let's go to Catherine and Walter. And then I think we have to close this down for today. Kimberly.
I was going to point out, and you know, this isn't always an information that the consumer has agreed to share. If you recall, they talk about disclosure of de-identified data, which we all know can in some ways be re-identified. I mean, it doesn't take much to re-identify data now, we know this. And it included the sharing of identifiable data if an independent and external review committee has waived the need for the requesting entity to obtain authorization from healthcare consumers, which was, for us consumer advocates, something we really were not happy with. But this is where we landed. And part of, I think, the reporting requirement was so that some consumer advocates and consumers themselves could get a better idea of how this data was being used to ensure that it, was, truly being used for population care management and not something else. To that end, and maybe this is too big of an ask, but if we're going to reconsider any procedure, it might be worth looking at how some of the data is being used. Look at some of these reports. Frankly, admittedly, I mean, I haven't gone to look at the reports. I suspect they would be very difficult to find. And I suspect they probably don't have a lot of the data that would be helpful in sort of in taking a look at that information. But that was my recollection, because again, these rules certainly did allow for data to be used without consumers' consent.
Yeah, and maybe it needs to your point, which you're sort of saying, but you didn't say it needs tightening up where. They're for research purposes under HIPAA, they have to, I think we've heard folks say already, you have to give consent. So, I mean, maybe there's more to this than that we need to look at. But those are good points. Catherine and Walter, and then let's see if we can keep these in under a minute so we try our best to keep everybody on the time. So let's see what we can do. Catherine.
Thanks, David. And I'll be brief. Really, as Walter pointed out and Sally Ann in the chat, this is not provider burden. This is specific to an HIE. And remember, this is historical, like decade plus historical. So Kim, I think your memory is spot on, consistent with what I recall. We had very strong consumer advocates that needed transparency and wanted transparency to where their data was going to be provided. That is why even for burden on an HIE, we landed on a very summary level of reporting. And so it was completely driven by that. And I certainly think things have changed a little bit more, right? Never mind what the public health world has looked like in the last, couple of years. So certainly modernizing this a little bit probably makes sense, but I certainly hope that we don't lose the consumer advocate perspective that was originally the intent in this section.
Yeah, and that's true. That's a very good point. And times have changed. The HIEs really weren't doing much with population health data, and I don't even think there was a sense that they would be, but certainly the times have changed and now they are. So, and it isn't provider focused, it's HIE focused. I think that's good to keep us recollection of. Dr. Suarez, you get the last word, and then Alana's going to tell us next steps.
Okay, mine is very quick as well. Yes, I do think we need to go back and revisit all this, because my big concern is there's those 3 levels of data that I mentioned: aggregate, meaning really truly de-identified, even though it's almost hard now and almost impossible to de-identify, but there is still de-identifiable data. If one eliminates all the 18 quote unquote identifiers under HIPAA, then that HIPAA calls that de-identified data, or if it's a statistician that defines it. So that's one group of data. The other group is, of course, limited data set, and the third group is really truly protected health information, individually identified. And there is instances where each of those 3 are released for this different purpose, non or secondary use purposes like population health management or even research. And so I think we need to review which ones merit really truly developing reports and what level of detail those reports should go. Because, yeah, I mean, I understand from an HIE perspective, they do a lot of data. They do a lot of things with de-identified data, and trying to document that in great detail will be overburdensome. So anyway, and I think it would be helpful to understand in other settings what states do with respect to reporting this type of data. Because I know in other states, there's 21 states that collect something called all payer claim databases, which is all the data from all the claims of all the payers in that state. And they have this type of reporting that is done, and a summary report of who accessed the data for what purpose, all these details. So it might be helpful to look at some of the examples in other places. Thank you.
And Maryland is an APCD state. In fact, we manage that here. So, okay. So, Alana, before you get started, let me just ask Alexa if she could come on camera for a moment. Wanted to introduce her to the group here. She is our new AAG, and we're thrilled to have her on board. She will be joining these meetings. So she's listening and will have lots of questions and be able to offer lots of guidance to staff as we keep moving forward. But I wanted everyone to get a chance to say hello to Alexa. Alexa.
Hello.
Great to have you.
Thanks.
And Alana, take us home for the day.
Thanks, David. So I know I saw a couple of hands being raised as we were closing out. So Reverend Connor, Luis, if you have other final thoughts, please feel free to send those to me. We'll make note of them and we can pick them back up during our next meeting, which in terms of next steps, we have our next meeting date tentatively scheduled for April 26th from 2:30 to 4:30. We will be sending an invitation out soon, and we hope that you all will be able to join us to follow up on the conversation today and potentially, I think, close out the review of sections 11 and 12. So that will be our intention and hope. We'll see where the conversation takes us. But aside from that, I think that's all we have in terms of next steps. So thank you all very much for joining us, and we'll look forward to the next meeting. Anything else, David?
Nah, thanks everyone. Great conversation. We couldn't do this without you. So a huge round of applause for all the great contribution and to the folks that have been with us for such a long time, and we welcome all the new folks. So have a great evening, everyone, and we'll see you in April. Take care.
Thank you, everybody.
Thank you. Goodbye.
Bye, everybody.
Thanks, David. Bye.
So I think it's the three of us. Are we still recording?
Yep. 1 second. Sorry.